What's an ALR hearing in a driving while intoxicated case? An ALR hearing refers to an administrative license revocation hearing. These are conducted through the State Office of Administrative Hearings. And as the name implies, it's administrative in nature. It's not criminal in nature, and it's not civil in nature. Criminal cases have to be proven beyond a reasonable doubt. But when you get to the administrative hearing, the DPS agents or the attorney for DPS only have to prove their case by preponderance of the evidence. That's a tipping of the scales in their favor. Additionally, they're not trying to prove that you're guilty of the offense of driving while intoxicated. DPS has to prove 4 things at an ALR hearing typically. First, that there was reasonable suspicion to stop you, assuming there was a stop. Second, that there was probable cause to arrest you. Third, that after you were arrested, they read you the statutory warning that asks for your consent for breath or blood. And fourth, that after receiving the warning, you refused to give consent, or they did obtain a specimen, but the specimen showed that you were a 0.08 or greater blood alcohol concentration. Those are the only things that DPS has to prove at the hearing. And they're proving it at a much lower standard than would be required in a criminal court. In fact, in North Texas, DPS has traditionally or historically won those hearings in about 85% of the cases. So why would you go through with an ALR hearing? There are many reasons. First and foremost, it extends the period that you're allowed to drive without restriction. So the notice that you receive after being arrested for DWI tells you your temporary driving permit is good for 40 days. But if you request a hearing, you can continue to drive until you get the hearing. So if it takes 100 days to get to the hearing, that's 100 days you drive without restrictions arising out of potentially what will come later, which is an occupational license. So that's one benefit. The other benefit is we as your attorneys can subpoena the primary officer to appear at these hearings. Now, sometimes they're virtual, sometimes they're in person, but the benefit of getting an officer on the stand at an ALR hearing is they're not as prepared as they would be at a criminal case. And they're now on record giving testimony about what they recall. So if what they recall is different from what's in the report or potentially what they would testify to in trial one day, that's very, very valuable for us. Finally, it gives us time to prepare a petition for occupational license. And what that means is we are prepared for the possibility or likelihood that we won't win the ALR hearing. The occupational license is a petition that goes to a civil court, and the civil judge can give you permission to drive to do all the things you need to do in Texas, not just get to your occupation, but pick up your kids, go get groceries, anything that you need to do, particularly in light of the fact that Texas really doesn't have great public transportation options. So we get you set up to get the occupational license if you need it. We made this video in response to questions that we commonly receive, as well as questions that have been left on our YouTube channel. So if you have a question about criminal law in Texas or any federal criminal law, drop us a comment below and we'll be happy to answer that in a future video.